So when a grantor transfers land conditionally, is that an estate at will, a defeasible estate, a life estate, or a fee simple estate? What do you guys think? When we're doing this conditionally, we're saying, remember, the grantor is the one giving the deed. The grantee is the one receiving the deed. So if I transfer the land to you and I say, oh, but Cerinthia, listen, there's a caveat on this. You can't do this. You can't do that. And if you do, I may take it back from you. Yeah, I could take it back from you. That's the defeasible estate, right? It can be defeated. Your ownership could be defeated. So it's fee simple defeasible. There's another one where I can't take it back from you. What's it called when I transfer property to you and there's no conditions? Like, I'm out of here. It's yours. Take it and go. What do we call that? Anybody remember the term for that? So fee simple defeasible is where it can be defeated. I could take it back from you, but what if I can't take it back from you? And that's fee simple absolute, right? Everybody remember fee simple absolute. I'm granting it to you without any of that holdback. I'm letting you do what you want. I give it to you and I'm out of here, right? All right. Good job, guys. Next question. Commonly, the dependence upon a stated event which must occur before a contract is binding. So I'm saying, I got to do this before I'm going to be held to this contract. Is that laches? Is that contingency? Is that status? Or is that waiver? So this is contingency. I'm saying, hey, this thing has to happen before this other thing happens. Now, what are some common contingencies that we might see in a real estate contract? What are some common contingencies that we might see in a real estate contract? So the one I think of, I'd say the most common one that you see the most is the finance contingency. That somebody said this, James said the sale of the current home. That's a good one. Yeah, Christina said appraisal contingency. It has to appraise. That's a good one. Cerinthia said the approval, the financing approval, seller fixing some repairs. Valita said that's a good one too, right? That I need you to fix these things before we move forward. So that's the contingency. And remember, when we're talking about a contract that's contingent, that we still have things to accomplish before it closes, that's an executory contract. But what about when the contract is all said and done? We're done with it. We've completed everything. What kind of contract is that? What do we call that? When we've got everything done and completed. Very good. Christina got that one right out of the gate. Executed. Delita got it. Yes. An executed contract is one when we've done everything there is to do. We're good to go, right? We're done. It's finished. All right. Next question. The current right to possess. With the right to acquire legal title once a preceding condition has been met. The current right to possess, remember what we mean by right to possess. Think about that. It could be with ownership. It could be with leases, right? With the right to acquire legal title, so the deed, once a preceding condition has been met. Is that actual interest? Is that possessory title? Is that possessory interest? Or is that equitable title? Right? Which one do you guys think? Yeah. So this is equitable title. What's the difference between legal and equitable title? Well, here we know equitable title means that we have a certain interest in the property, but once I have the deed, I'm said to have legal title, right? So let's give some examples of when we have equitable title. When are some times we might have equitable title? What if I had a purchase contract in place with Carolyn? That's equitable title. I have equitable title. I'm trying to purchase Carolyn's home. I have equitable title. What about when I have a deed of trust? The trustee is holding on to the deed, but as the trustor, what do I have there? I have equitable title, right? I have an interest in the property. Or if you're in a state that does traditional mortgages, the lender has equitable title because they have a lien on the property, but I have legal title because I've got the deed, right? Makes sense? All right, next question. We have a general term used to include any property which gives the owner certain income tax advantages, such as deductions for property taxes, maintenance, mortgage interest, insurance, and especially depreciation. Is this a tax lien? Is this a tax shield? Is this a tax roof? Or is this a tax shelter? Yeah, this is the tax shelter, you guys. This is the tax shelter. Now, when we hear the term tax shelter, we automatically think, well, that sounds like something negative, like a tax shelter sounds a little seedy, right? But no, not really. A tax shelter is designed to be a tax shelter, right? There's nothing necessarily wrong with having a tax shelter. It's just a way that the government gives us that we can legally avoid paying taxes under certain circumstances or pay reduced taxes under certain circumstances. So, real estate is a very good certain rental properties and things like that are considered to be very good tax shelters. So that's a good way to look at that. All right, our next question. In addition to a will, which modifies the will by adding to it, subtracting from it, or clarifying it, is that the abstract, the waiver, the novation, or the codicil? What do you guys think? In addition to a will, which modifies the will by adding to it, subtracting from it, or clarifying it? This is a tricky one. Yes, very good. Some people are like on the fence on this one. But yeah, this is the codicil, right? A codicil, I'm changing my will. So if I left everything in my will to William because he's my best friend, and then we get in a huge fight and I go and I change my will, and I take William out, that's a codicil. Now, some people said novation. So let's talk about what does novation mean? Novation is when I'm replacing the old with the new. Think of it as something novel, novation novel, something new. So if I have a contract with Carolyn and it's not working for us anymore, we could replace the old contract with a new contract. That's novation, right? When I'm replacing the old contract with the new contract. Or what if I had a contract with James and James needed out of the contract and I was willing to let James's brother Bill come in his place? I'm replacing one person with a new person. That's another form of novation. If I die without leaving a will, is that untestate, intestate, testated, or testate? If I don't have a will. We're on the death words again. Sometimes we get on these. All right, I'm just randomly picking them out and they're just coming to me here. So if I die without leaving a will, that is definitely intestate, right? Dying without leaving a will is intestate. So let's think about this for a minute. If I die without leaving a will, I die intestate. And let's say that I do that. I don't have a will and I die. The courts are going to appoint somebody. Let's say they appointed Valita to go and make sure that all of my stuff gets distributed out to my relatives and people that's supposed to get that stuff. I didn't choose Valita to do that. The courts chose her because I died intestate. If I had died testate with a will and I had chosen somebody, they would be called my executor. But what do we call Valita when the court appoints somebody to take care of my property? What do we call that person? That's the administrator, right? The probate court would appoint an administrator to ensure that all my property was divided equitably how it's supposed to be. If I picked my own person because I died testate, we would call it an executor or an executrix. All right, good job. Next, the legal right one has to possess land. The legal right one has to possess land. Is it estoppel? Is it eminent domain? Is it deed? Or is it title? The legal right one has to possess land. What do you guys think? Estoppel, eminent domain, deed, or title, right? So yeah, it's title. Good job, guys. Title. So think of it like title is like the idea of ownership. It's the legal right. It's the feeling. It's the understanding. It's the belief. It's the thing that's like happening there, right? But the deed is the paper. So title is a concept. It's a right. It's a legal idea. But the deed is the manifestation of that title. It's the paperwork that comes with it that helps. Sometimes we use these two terms interchangeably, and that's okay. But I want you to know the little subtle difference between those two because it is a little bit of a difference. The deed is a physical thing. The title is a concept or an idea. All right. Next, we have evidence of title being passed from a grantor to a grantee. Is it a writ of execution, variance, title, or deed? Which one is that? Is it a writ of execution, variance, title, or deed? Yeah, so the evidence of the title, like we just said, is the deed. It's the paper. It's like, here, you have title to your house. All right, Christina, show me the title. You would show me a deed, right? You would show me that you had title that way, right? Exactly. Very good. Now, Let's talk about another word that's not the answer to this question, but it tends to stump people. What is a variance? It's unrelated to the deed, really. But when would I ask for a variance? And who would I ask for a variance? Even better question. First of all, who would I ask for a variance? Very good. Nardine said the zoning folks, right? I would go to the zoning folks usually and ask them for a variance. And in a variance, I'm asking to do something that's usually against the current zoning or rules of the area, because without being allowed to do that, usually I would have a hardship. So basically, it would make my land or my property less valuable or useless even by not being granted this variance. I'm saying, like, let me get around this rule here. I want to ask for permission to break the rule before I do it. And if you grant that to me, that's called a variance, right? Christina, that's a good question. So a special exception is a little bit different than a variance, because in a special exception, they're usually giving me permission to do something that's against the current zoning rules or building rules, because it's for the public good specifically, not just because it created a hardship for me, but because it's for the public good. So when we think of a special exception, it would be something like a school or an urgent care, something the community needs there. And so they're going to let them put it there, even though they normally would not be allowed to under the current rules. Good question. All right, our next question. One who, for a fee, brings together a borrower and a lender and handles the necessary applications for the borrower to obtain a loan against real property. Okay, trustor, beneficiary, lender, or mortgage broker. All right, getting a lot of D's here, right? This is the mortgage broker. Now, why is the mortgage broker and how are the mortgage broker and the lender different? Remember, the mortgage broker and the lender are not the same. The lender would be, or the loan officer that works for a bank would be working for that bank. They are selling that bank's loans, that bank's products. That's it. So if I walk into Chase Bank and I actually ask to talk to a loan officer, I'm going to talk to somebody who's going to hook me up with a loan from Chase Bank. But if I went to a mortgage broker, he or she is a salesman just like we are. And what they're doing is they have a lot of relationships with a lot of different lenders, and they're going to go out and they're going to shop for the best deal for me, and they're going to try to hook me up, right? And that is what the mortgage broker does. And when he finds me the good deal, he gets paid for his work. There you go. So happens when someone dies without leaving a will. This happens when someone dies without leaving a will, a writ of execution, intestate, injunction, or testate. And everybody remembered that from a couple questions ago. They're just coming back and rewording it and asking me in a different way. And of course, that's intestate. But let's talk about an injunction. Who can order or who can issue an injunction? The courts, the judge can order injunction to make me stop doing something, right? That's an injunction. All right, our next question. So here is one that's a little tricky, right? We're using a lot of terms and things, but hopefully you guys will recognize an important number in this question. A measure, usually of land, equal to 160 square rods, or don't ever forget this, 43,560 square feet in any shape. Is that a board foot? Is that plot? Is that an acre? Or is that a lot? What do you guys think? What has 43,560 square feet? 4 old men driving 35 and a 60 is our memory trick, right? That's our acre. Don't ever forget that. You will definitely need to know that in life and possibly for your exam, that there are 43,560 square feet in an acre. Now, you know, our way our brains work. If I've said to you, hey, this property, my house, for example, is on a half-acre lot. Now, most of you can visualize how big my yard is. We all know how big an acre is. We can kind of visualize how big a half acre is. It's a pretty decent sized lot for a subdivision, right? But if I said to you that my lot is 22,000 square feet, you probably can't visualize that as easily as if I say a half acre. So sometimes we need to translate between these two, ways of talking. So don't forget how to do that, right? When we're talking to clients, when we break things down into quarter acre, half acre, or an acre, people can visualize that pretty easily. I don't know why, but the square footage thing, we tend to go, okay, if it's not something I'm used to talking about all the time. A clause in a listing which states that if a property is sold during a specified period of time after the expiration of the listing to a buyer procured by the broker, a commission shall be owed. What do we call this? Is this safety clause? Is this alienation clause? Is this acceleration clause? Or is this assumption clause? What do we call it? It has another name. It's called a broker protection clause. Anybody remember that? Broker protection clause? But it also is called the safety clause, right? It's called the safety clause or the broker protection clause. What it's meant to do is to make sure that if I introduce a buyer to the property during the listing period, and then the listing expires, for example, that for a certain period of time, if that same buyer comes back and buys directly from that seller, I don't get cut out of my commission because I did the work and the energy and put forth the effort to bring that buyer to the property. They knew about it because of me. I introduced it to them, and therefore I should be able to protect my commission. And that's called a broker protection clause or a safety clause, and we would put that into our listings. All right, a way of funding specific local improvements. Is that a mechanics lien? Is that a judgment lien? Is that a mortgage lien? Or is that a special assessment lien? Which one is it? Mechanics lien, judgment lien, mortgage lien, special assessment lien. What is this? It's a specific improvement, like a sidewalk. A few years back, they did gutters in front of my house. I got a special assessment for that, right? So remember, property taxes are going to go on for as long as I own the property. I'm always going to owe those as long as I own the property. But a special assessment lien is for a special project. It's for a short period of time, usually, that I pay that back. And once I've paid off that special assessment, then it just goes away. Whereas property taxes go on forever and always, right? All right, our next question. Depreciation that occurs because of factors outside of the property. Is that functional obsolescence, economic obsolescence, physical deterioration, or manual deterioration? What would that be? Functional obsolescence, economic obsolescence, physical deterioration, or manual deterioration. It's happening outside of the boundaries of my property. Therefore, it's economic obsolescence. But what is if when it happens within the boundaries of my property, it's something that I can control? My example is, for example, when I moved into my house, it had a wet bar. For those of you who've heard this story before, sorry, but a wet bar, like a lot of the younger people are going, what the heck is a wet bar, Maria? It's like if you're too drunk to walk from the family room to the kitchen to get your drink, there's a sink right there in the family room to make life easier for you, right? And it was popular in the 70s when everybody was drunk all the time and having wild parties, right? Nowadays, that's not a real popular feature, and we don't see it put into new homes. But my house had it. It's not very practical to have a sink in the middle of the family room. That was functional obsolescence. I could do something about it. I could fix it, but it wasn't what today's buyer was looking for, right? There you go. All right. So liens that apply to all of the owner's property in the county of recording. Everything in the county of recording. It can go on any property that they own there. Is this property taxes, general liens, mechanics liens, or specific liens? Property taxes, general liens, mechanics liens, or specific liens. What kind of lien is it that can go on any kind of property that I own in that county? Yeah, the general lien. So you guys, while we're on this topic, tell me some examples of general liens. What could be an example of a general lien? It's going to be the federal tax liens. The IRS liens are general liens. That's a great example. Another one could be judgment liens. You take me to court, you get a judgment, you win a judgment against me, I can come after you as a general lien. So now let's we talked about general liens. What would be an example of a specific lien that would go on a specific piece of property? Not everything that I own in the county, but one specific piece of property. Property tax liens, very good. That's a great one. Also, what else besides property tax liens? Mechanics liens are specific liens. Yeah, mechanics liens are specific liens. Mortgage lien is a specific lien. If I took out a mortgage on that property, they would put the lien on that property and not on my investment property on the other side of town. So there you go. When something is taxed based on its value, is that quiet title action? Is it ad valorem? Is it a tax shelter? Or is it impounding? What do you guys think? When something is taxed based on its value, quiet title action, ad valorem, tax shelter, or impounding. Yeah, ad valorem, right? It's according to value. Ad valorem literally is according to value. So if my neighbor Jerry next door has a house that's more valuable than mine, he's going to pay more in taxes than I am because it's based on the value of our house. That's ad valorem. So while we're on this screen here, let's talk about another one. When would I have a quiet title action? What would cause me to have to do a quiet title action? The cloud on the title. If I have a cloud on the title and I can't resolve it through the normal means of finding, say, Carolyn and having her sign a quitclaim deed if she's showing up on the title and she's not supposed to be, whatever it is, I can't get it resolved. And I go to the judge and say, oh, I need some help here. I've done everything I can to get this resolved. I need to get my title back in order. What can you do for me? And I would file a quiet title action at the courts and they would hopefully get that resolved for me. Very good. Very good. Next question. One who grants property or property rights. One who grants property or property rights. Is that a grantor? A grantee, I guess it is. Grantus or grantee? Which one is it? Grantor, grantee, grantus, grantee. That was a lot to say. That's the grantor, right? The grantor is the one that's granting the property rights to me. All right. So an estate and real property for the duration of the life of a person. Only while I'm alive do I own this property. What do we call this? Yes, this is the life estate. So let's talk about life estates for a minute because I will tell you, people get these messed up in their heads all the time. This is one life estate that a lot of people struggle with this idea because it's kind of weird if you think about it. So let's say that Stacy is my sister and I have a property and I say, okay, Stacy, I'm going to give this property to you for as long as you're alive. But when you pass away, it's going to come back to me. What kind of a life estate is that? What do we use? What's the term I'm looking for there? I gave it to Stacy. She owns it only for as long as she's alive. And then when she passes away, it automatically comes back to me. Remember this one? That's the reversionary interest, right? It reverts back to me. But what if instead I said, Stacy, I'm going to give you a life estate. You own this property for as long as you're alive. But when you pass away, it's going to go on to Christina. Christina gets what's left. She's the remainderman. Very good. Carolyn got it right off. Remainderman. She gets what remains, right? So if it reverts back to me, it comes back to me. I'm the person who gave the life estate. Then that's the reversionary interest. If it goes on to somebody else after Stacy's gone, then that's the remainder interest. Now I'm not quite done with life estates yet. So here's my next thing on life estates. What about if Christina was my sister and I said, Christina, I'm going to give you a life estate, but only as long as our mother's alive. I want you to come to this house. I want you to take care of mom. You and mom live here. You own it, but only as long as mom's alive. Not as long as Christina's alive, but only as long as mom's alive. What do we call that kind of life estate where it's based on the life of another person? What do we call that? What do we call that? That's a tricky one, right? Purautrvie. Purautrvie. Yes, that's exactly right. Purautrvie. Now, we've kind of gone through all the life estate things, but I'm going to give you one more thing about life estate. What if Christina had been granted the life estate by me and she put in her will that when she died, Bob's going to get the life estate property. Bob's going to get that house. What happens then? I gave the life estate to Christina and she gave it away to Bob in her will. Oh, that wasn't very nice, right? What happens to Bob in the will and all that? But if we're talking about a life estate, does Bob get anything? What do you guys think? No, Bob doesn't get it because Christina's ownership ended when she ended, to be blunt. So when her life ended, her ownership ended. What she put in her will is neither here nor there because we don't look at that until after Christina's dead. So she doesn't have any ownership interest. Once she's dead, it's done. Right? So that Bob would not get that. Very good, you guys. That was a lot of life estate.